Hey y'all, today I want to talk about the intricacies of US copyright law as it relates to recipes and help you gain insight into how much protection culinary creations can receive under US intellectual property laws. Let's start with the basics. US copyright law protects original works of authorship with a modicum, meaning minimum creativity, expressed in a tangible form. These works can be literary, dramatic, artistic, or musical works. All the US Copyright Office really asks for is that what you create is an original expression of ideas, but not the idea itself, and that it be fixed in a tangible form, be it on a piece of paper, on a flash drive, just if you can put it in a tangible form. Food recipes are literary works under US copyright law. To protect their brand, restaurants and chefs use names, logos, slogans that identify with the products or services associated with it. And this is usually done through trademark protection under US trademark law. But to protect actual recipes, we must turn to another kind of intellectual property, one that identifies a dish as an art form, not as a source identifier. This is how one would think of protecting recipes through copyright law. The Copyright Act defines a literary work as any form of expression in words, numbers, or other symbols or indicators, regardless of the medium used to embody them. This includes books, manuscripts, phonorecords, film, tapes, discs, and cards, excluding audiovisual works. Furthermore, according to US Copyright Office, a literary work is a type of creation that utilizes narrative, descriptive, or explanatory text to convey a particular subject, theme, or idea instead of relying on dialogue or dramatic action. Merriam-Webster states that a recipe is a set of instructions for making something from various ingredients. Seems pretty obvious that food recipes would be considered literary works, right? As they consist of written material, usually published in a recipe cookbook, blog, or other tangible forms such as newspapers and magazines. Although, for legal protection, food recipes would fall under literary work, the mere listing of different ingredients and spices will not be considered. What copyright law asks for is a substantial literary expression. So for copyright protection for chefs and cookbooks for recipe production, the idea-expression dichotomy limits the protection around a food recipe. This is where US copyright law does not allow the protection of an idea, but the expression of the idea. There are many variations of a classic dish. I love chicken biryani, that's one of my favorite dishes, but there's so many different versions of it spread across all over India, Pakistan, and other countries in South Asia. And there's variations of it that even exist in the Middle East. So, like I said, there are many variations of a classic dish, but for recipes to be protected as literary works, there must be a substantial literary expression. What does that mean? You must include content beyond the ingredient list. The idea-expression dichotomy means for recipes that to be copyrighted, an individual recipe will need more than just a mere listing of ingredients and directions associated with them. Creative expression around an idea for individual recipes, blogs, or cookbook development looks different for each writer. When creating recipes for a cookbook, it is essential to understand the limitations of what is protectable. This is why it is vital to consult an intellectual property or copyright lawyer usually from the inception of the project. Creating a new dish takes months of testing, various methods and processes. It isn't as much as about the resulting dish as it is about the process that led the author there. Drawing inspiration from diverse cultures, childhood memories, and travel experiences can help safeguard a collection of recipes or an individual one. Exploring different aspects of life often leads recipe creators to delve into the history of cooking techniques. This allows some to appreciate the significance of an ingredient while others use it to showcase a deserving community. It's crucial to provide a detailed description of each ingredient and steps of significance. Some are creative enough to include relevant information about the chemical processes involved while cooking. Okay, Writing about a chemical process isn't necessarily crucial, but showcasing a unique creative expression like that around why the recipe is important enough to be published is. Publications and consumers are interested in the story behind your recipes, not just a list of ingredients and directions. Now, how can you continue to protect your already published material? Well, use copyright notices for recipes, no matter where you publish them. A copyright notice is a statement by the author informing the public that a copyright holder is claiming ownership of the published material. A notice usually consists of the date of first publication, the name of the copyright owner, and the copyright symbol right next to it. Using it as an anti-plagiarism measure is common, but it can also serve as evidence in copyright infringement cases where the defendant seeks to avoid responsibility. An alternative to copyright protection for recipes is trade secrets. You might ask if someone can protect specific ingredients involved in a recipe or a process that's involved in recipe development. Although copyright protection will not extend to specific ingredients, this is where creators turn to trade secrets. Think Coca-Cola or KFC's secret blend of herbs and spices. Trade secrets, more specifically, non-disclosure agreements, are a way to protect confidential information. That is a competitive advantage within the industry. It's essential to establish strict policies to safeguard the techniques and procedures used in a recipe, which are seen as a competitive advantage in the industry. The critical aspect of protecting something as a trade secret is that it must remain confidential. So for it to be a trade secret, it needs to remain a secret. It is advisable to seek guidance from an intellectual property lawyer who is familiar with implementing processes like these to ensure that the appropriate processes are in place to maintain confidentiality. As always, this is Sahil Malhotra. If you have any questions regarding protecting your recipe through copyright law, feel free to reach out to Drishti Law at www.drishtilaw.com or 773-234-1139. Thanks for watching.